Clay Doggett, please report to the front.
Good afternoon. It's 2 o'clock by Finance Committee scheduling. So we welcome you back. And I'd like to call the Finance Ways and Means Committee to order for April 20th, 2022. Second round. Madam Clerk, would you please call the roll?
Representatives Campbell, Camper, Crawford, Faison, Freeman, Gant, Garrett, Gillespie, Hawk, Hicks, Hodges, Lamberth, Lynn, Miller, Ogles, Sexton, Shaw, Sparks, Todd, Whitson, Williams, Wendell, Zachary, Vice Chairman Baum, Chair Lady Hazelwood.
Here.
Madam Chair, you have a quorum.
Thank you, Madam Clerk. Do we have any announcements or personal orders before we begin? If not, item number 1 on our calendar for this afternoon is House Bill 2656 by Chairman Halsey. Chairman Halsey, you are recognized. We have a motion and a second. You are recognized.
Thank you, Madam Chair Lady, and thank you, committee. House Bill 2656 is Speaker Sexton's bill, and I'm honored to help move it along. It is an attempt to begin to bind up some of the wounds that have been caused by the criminal justice system, the way it operated for the past several years as it relates to victims and victims' families. Because when a judge gives a sentence or a jury gives a sentence, there is absolutely no one who knows how long somebody is going to be in the penitentiary. And the red date moves constantly. The DA can't tell you, the judge can't tell you, the jury can't tell you, the defense lawyer can't tell you, Department of Corrections can't tell you, nobody knows. So these families find themselves when all of a sudden they're issued a notice that they got a parole hearing and they've got to go beg a parole board to keep this person in the prison. So this bill fixes this when it comes to violent crime. This bill says that these first 20 offenses that are serious violent crimes, you will serve exactly what the judge or jury gives you. There'll be no question, everybody will know. Now, there might be another amendment coming on this, but the amendment that I have sets 5 of these things apart and allows not sentencing credits as you know them, but programming credits. You can earn 10% credit if you participate in an educational program, vocational program, or substance abuse programs. So 5 of these offenses allow that up to 10%. And that's the bill.
You've heard the sponsor's explanation. As mentioned, there are a number of amendments on this bill. I understand that we're moving forward with the amendment drafting code 017851 by Leader Lamberth. Is that correct?
Yes, ma'am, Madam Chairman, I would move that amendment.
All right, and it is an untimely filed amendment, so I'll need a motion to consider. A motion and a second. Without objection, we will consider the amendment. And with that, Leader Lamberth, you're recognized.
Thank you, Madam Chairman. And this amendment does, in large part, what Chairman Halsey has already described. And I will say, Chairman Halsey and I have been working on this for a long time. So has the Speaker. There are many, many people. In fact, the governor's worked on this for years and years. First time I met our governor was on a task force that Bill Haslam had put together and trying to figure out what's the best way to go about criminal justice reform so that we are tempering justice with mercy. And last year we passed some extraordinarily good bills that this body supported, that our governor put forward, that shows mercy to a lot of folks and puts a lot of really good programs out there and gives a lot of folks a second chance to prove that they can reenter society and do right. There's a few crimes that involve victims that you just have to make sure at the front end of the sentence, everybody knows exactly how long the sentence is going to be. And those sentences have to be swift, they have to be certain, and they have to send out a message loud and clear that if you're going to commit homicide, if you're going to commit vehicular homicide, and I'll say this one has always struck home to me very closely, and most of you in this room will know this, but just hang with me for a moment. I don't talk about it a lot publicly, but the reason I'm sitting here today is that when I was just 2 or 3 years old, a drunk driver killed my Aunt Lola, my mother's sister. And I saw from the eyes of just a kid, I don't even remember it. I've heard the stories my entire life about what happened. But I grew up in a family that had to deal with the fact that my Aunt Lola never got married. She never graduated high school. She never got an opportunity to have a job or a family or anything else. And we got drugged through the criminal justice system and whipsawed back and forth until I was a young man. And it literally is something nobody should ever, ever, ever experience. So as a first generation college student, I went off to law school, and the only thing I ever wanted to be was an assistant district attorney. And I went and worked for the man, Ray Whitley, who's the district attorney in Sumner County, who prosecuted the fellow who killed my Aunt Lola. I've seen family after family after family have to go beg the parole board, and so is Chairman Halsey, to keep the person in prison that killed their loved one. It's got to stop, and it ends today. This amendment allows for a very few of these crimes, not vehicular homicide, not the other listed offenses, to be able to get up to 15% program credits. So if they want to get into a program in prison and get out just a little bit early, there's no parole board, there's nobody to go beg for the defendant or the victim's family to go, but they can get out a little bit early if what they'll spend their time in prison in a way that will help them not re-enter the criminal justice system. That's the goal. For everybody else, if somebody gets, for instance, a 10-year sentence, it's going to be 10 years, period. For these few crimes. For everything else, we already have laws on the books to be able to help these people. Now, thank y'all for just hearing a little bit about my family history, but it's a part of who I am. And if there's any single family out there that's listening and watching this bill closely, because members, I promise you, there are hundreds that are, and many of them have contacted you, I'm sure. This stuff matters. So from here forward, every family will know that when the judge says 10 years, it's 10 years. And I hope anybody that might even think about, for instance, getting behind the wheel, intoxicated, endangered others' lives, will understand that if you do that crime here, you're going to do real time. This will be the toughest truth in sentencing bill anywhere in the country. It will make Tennessee safer. It will make a difference for our future. And I ask you to support this amendment. Thank you, Madam Chairman.
All right, members, you've heard the sponsor's explanation of the amendment. Are there questions? What we did. I'm pretty sure, but we can do it again just to be absolutely certain. We have a motion, we have a second, we have a motion on the amendment, and I believe Representative Hodges had a question.
Thank you, Mr. Chairman. Just what are the 5 offenses that are exempt?
Excuse me.
Chairman Halsey.
Thank you.
We'll let Leader Lambert, since that may be a part of the amendment, we'll let Leader Lambert answer that question.
And actually, if we could go to legal on that, just to make sure they get the 5 properly listed.
I have 5.
Joel Hayes, Office of Legal Services. According to the fiscal notes, the sentences that, let's see, 100% of the sentence imposed by the courts, undiminished by service credits, applies to the following offenses. So it's attempted first-degree murder, second-degree murder, criminally negligent homicide, vehicular homicide resulting from the driver's intoxication, aggravated vehicular homicide, especially aggravated kidnapping, especially aggravated robbery, carjacking, and especially aggravated burglary. Those are your 100%. Legislation requiring 100% of the sentence imposed by the court with release eligibility at 85% served with credits applied are for the following offenses. Aggravated assault if the assault involves the use of a deadly weapon. Reckless aggravated assault if the offense involved the use of a deadly weapon. Aggravated assault, I'm sorry, the previous one was reckless aggravated assault if the offense involved the use of a deadly weapon. Aggravated assault if the offense involves strangulation or attempted strangulation. Aggravated assault if the offense results in serious bodily injury or death of another. Aggravated assault against a first responder or nurse if the offense involved the use of a deadly weapon. Aggravated assault against a first responder or nurse if the offense involves strangulation or attempted strangulation. Voluntary manslaughter, vehicular homicide creating a substantial risk of death or serious bodily injury, and the contact and involving drag racing or within a construction zone. Reckless homicide, aggravated kidnapping, involuntary labor servitude, trafficking persons for labor or services, aggravated robbery, aggravated burglary, aggravated arson, possessing a firearm during the commission or attempt to commit a dangerous felony, and manufacture, delivery, or sale of a controlled substance after 2 or more convictions. All have 100%, but are eligible for at 85% based on credits earned.
Leader Lambert.
Thank you, Madam Chairman. And again, it's different categories, and obviously it's several different offenses. All of these are 100%. The second ones that you heard listed have that 15% eligibility if they do the programs while they're in. The first list that you heard are 100%, and there's no reduction whatsoever. In neither scenario would a defendant's family or a victim's family have to appear before a parole board. And so it's at the beginning of the sentencing, when the sentence happens in court, when a judge actually issues that sentence, then at the very beginning, everyone is going to know what exactly the sentence is. For that second group of crimes, again, up to 15% could be. This is very similar. The 85%er, the 85% there is very similar to what we have on the books now for several crimes, but it does increase these up to that 85%, these crimes. The 100% is beyond anything that we have on the books currently, which is why it's reserved just for those particular crimes.
And just for those who were attempting to count, as our legal counsel went through, there are 9 of those crimes that require 100% without any kind of reduction. So again, we have other people on the list. Leader Camper, you're next.
Thank you, Madam Chair. I was just going to ask the leader, what was the major difference between the 2 amendments? Is this the portion that's the major difference between the 2 amendments, or were there some other things in there that was a major difference between his amendment we put on and the one we're considering?
Leader Lambert.
Thank you. And the one we're considering has that 85%, and the other one there was 90%. There's some other small shifts around, but that's the biggest shift, is that of the 2 categories, some of those went to 85%. And that matches in large part what's already in the statute. For other crimes that are not in this list, we already have 85% crimes that are on the books. This just matches up more similarly to that.
Thank you, Madam Chair. Thank you, Mr. Sponsor.
Representative Miller.
Thank you, Madam Chair. As you were going through the list of legal, you mentioned controlled substance. Was that in the 100% or the 85%, or what percent was that in?
Mr. Hayes.
Representative Miller, that was in the list that's eligible for the 15% reduction. So it's at the 85% list, and that's manufacture, delivery, or sale of a controlled substance after 2 or more convictions. You're based on credits earned, you can get to that 85%.
Representative Miller.
And under controlled substance,
That could be, we have in Tennessee, I think 6 different categories of controlled substances. So it's any of those.
well, let me ask you a question. Would marijuana be under those controlled substances?
I would have to look more closely at the actual language of the amendment, but marijuana is a controlled substance in Tennessee. Give me a moment. And then
And while we're waiting, Leader Lambert, I believe you had a comment?
Thank you, Madam Chairman. And as they're looking at that, and just as we get back on the final answer on that, I believe we're only talking about A, B, and C felonies as far as manufacture or sale. And so as we get that definition, I think that's an important distinction. We are only talking about the highest level of drug dealers that are out there. There are others that may be, in a resale situation that are lower level crimes, still felonies, but on the lower end. And we can check with legal just to make sure of this, but I believe we're only talking about A, B, and C felony drug resale. So you're talking about, those that are selling a large amount of drugs, not someone who, while still wrong and illegal, but not selling a small amount. So we're not talking about casual exchange. We're not talking about.
Representative Miller.
So based on that explanation, what is the law in reference to those substances, marijuana more particularly?
We are waiting for legal.
Okay.
Representative Miller, as the leader described, this would apply to A, B, Class A, B, and C felonies. So the Class C felony, we're talking about the lowest level that would apply to this with marijuana. And the amount of marijuana that would have to be sold would be, let's see, not less than 20 marijuana plants or more than 99 marijuana plants, or 4 pounds to 8 pounds worth of hash. So it's a significant amount of marijuana would be a Class C felony.
Representative Miller, did you have
Yes.
follow up?
That's the current law. Current.
Yes, and I do not believe that law is actually changing. We're talking about the sentences. And with regard to, and that's hash. So we're talking about for a Class D felony, if you're talking about which would not apply to this, we're talking about, containing not less than 10 pounds of marijuana nor more than 70 pounds of marijuana. So essentially over 70 pounds is when you're going to get into this Class C felony, which would, and that's 2 convictions, which you would serve at 85% as a minimum.
Representative Miller.
And that's based on the seller of that 70 pound, not the individual that purchase it, but to the ones that's selling it. I'm just trying to get some clarification.
The statute implies, or basically you are inferred to, when you possess an amount over a certain limit, you are inferred to be or considered to be possessing it with the intent to distribute. So.
Thank you.
Representative Hodges.
Thank you. So just one more question. Why was drag racing on there, just out of curiosity?
Leader Lambert.
Thank you. It's a vehicular homicide involving drag racing. You would still be eligible for 15% eligibility on that. It's still a vehicular homicide, but vehicular homicide via intoxication is at the 100% with no release eligibility. Drag racing, reckless driving, those are still, again, extremely egregious offenses, and the sentence would be increased. Right now, that release eligibility is at 30% for most offenders. And so that would just move it up to 85%, but there would be at least some release eligibility for those folks. But the drag racing itself is not on the list, only if it involves a fatality.
Representative Gillespie.
Thank you, Madam Chair. And I don't know if this is a question for legal or for the leader, but was aggravated assault with a deadly weapon on that list of 85%?
Mr. Hayes.
It is on mine. Aggravated assault with the use of a deadly weapon. It's on mine.
Representative Gillespie, yes. At the 85% category, aggravated assault, if the offense involved the use of a deadly weapon, is part of that list.
I don't have any other questions on my list. So without objection, we are voting on Amendment Code 017851. All those in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. The amendment is attached to House Bill 2656. Mr. Sponsor, do you have anything further to add before we vote on your bill?
No, ma'am, thank you.
We are voting on House Bill 2656 as amended. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2656 moves on to calendar and rules. And I will note that there is a slight difference in the fiscal note on this amendment that we just recently passed, and that will be reflected. I apologize, my allergies are doing me in. That will be reflected in the schedules that you will, the updated schedules that you'll get tomorrow. Thank you, Mr. Sponsor. That brings us to item number 2. House Bill 1976 by Deputy Speaker Johnson. Deputy Speaker, you have a motion and a second, and you are recognized.
Thank you, Madam Chair. House Bill 1976 exempts a veteran of the United States Armed Forces who is trained and certified as a medic or a hospital corpsman from the initial licensure fee for the Emergency Medical Services Board.
You've heard the sponsor's explanation. Are there questions? Seeing none, we're voting on House Bill 1976. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1976 moves on to calendar and rules.
Thank you, Madam Chair and committee.
Item number 3 on our calendar is House Bill 1981. We have the heavy hitters with us this afternoon, the Deputy Speaker, followed by the Speaker Pro Tem. Welcome, Speaker Pro Tem Marsh. We have a motion and a second. Tell us about your bill.
Thank you, Madam Chair. House Bill 1981 would codify the use of non-licensed and entry-level personnel to operate an ambulance. These non-licensed and entry-level operators will have no medical contact with patients above their scope. They will be accompanied by licensed personnel with appropriate medical training, and they will be required to enter further training within 12 months. They will be allowed to help lift a patient on a gurney and drive the ambulance, and they will be working toward getting their certificate within the next 12 months. With that, I'll answer any questions.
Thank you, Speaker. I would say, I know in my area, and I'm sure many others across the state, getting emergency services personnel, there's a workforce labor shortage there as well. So I think this will be helpful to many of us back home. Are there questions? Seeing none, we're voting on House Bill 1981. Going on to calendar and rules. All those in favor, please signify by saying aye. Any opposed? The ayes have it. House
Thank you,
Bill
Madam Chair and committee.
1981 moves on. Item number 4 on our list. House Bill 2573 by Chairman Doggett. You have a motion and a second. You're recognized.
Good afternoon, and thank you very much. What we're doing here is we're adding a designation to the driver's license or photo identification of persons who've been convicted of human trafficking and efforts to help enable law enforcement to identify them.
All right, members, any questions for the sponsor? Seeing none, we're voting on House Bill 2573. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 2573 is moving on to calendar and rules.
Thank you very
Chairman
much.
Doggett. Item number 5 on our calendar today is House Bill 2103 by Representative Alexander. We have a motion and a second. All those, Madam Sponsor, would you please tell us about your bill?
Thank you, Chair Lady, and thank you, committee. This bill came to me from the Tennessee Funeral Directors Association. It is a 3-part bill. It's for continuing education for funeral directors or embalmers, requiring them to do the last 5 hours of continuing education in a virtual, if it's virtual or in person, but just some interaction between the person taking the course and the teacher. The second part to the bill is unlicensed funeral assistant, bad actors. We had one in Middle Tennessee. We're trying to keep that from happening again. And the third one is pre-need sales agent for pre-need preparations for funerals. Do not have to have both the director's license and a pre-need sales license. If you already operate a funeral home, you already have a license to do business.
You've heard Representative Shaw, you have a question?
I just want to thank you for bringing this. It's a good bill. Thank you very much.
Thank you.
Any other questions or comments? Seeing none, we're voting on House Bill 2103. All in favor, please signify by saying aye. Aye. Any opposed? House Bill 2103 moves on to calendar and rules.
Thank you.
Item number 6 on our calendar is House Bill 2802. The sponsor has requested to take that off notice. So without objection, off notice. Item number 7, Representative Tim Hicks, Hicks of Washington. Do we have a motion? A motion and a second, House Bill 2455. Chairman Hicks, please talk to us about what you're doing with this legislation.
Okay, thank you, Chair Lady. I appreciate that. This bill is about creating an avenue and a simpler way for folks like me that's been in the home building business, or a plumber or electrician, to be able to enter into our high schools and teach CTE and vocational in our high schools. I think that we need kids that's growing up to be around people that's been out in the real world. I think it will help them. And I think it'll be a big asset, and this will just create a way for that path to be easier. There's a lot of us that are aging out of this profession. Yes, Chairman Hicks, your papa is getting older. It's happening, and this will be a way to get me maybe a fourth career. That's what I need. Yeah. So thank you.
You've heard the Elder Hicks explanation. Representative Sparks, you have a question?
I just wanted to ask, you mentioned highly effective mentor teacher. Can you just elaborate on the importance of the mentor aspect? Thank you.
Representative Hicks.
Thank you, Madam Chair. Yes, I mean, the department asked us to put that amendment in there because we didn't want to have to go back to college to be able to step into the arena to teach. So therefore, we felt like the best way to go about it would be paired with a mentor teacher instead of somebody like me having to go back to college. So, because that probably wouldn't work out real well. So that was a good plan, and I appreciate the department working with me on that.
I see no other hands up, so without objection, we're voting on House Bill 2455. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it, and Representative Hicks, you can totter on to calendar and rules.
Thank you, and thank you all for all you're doing. Thanks a lot. Appreciate y'all.
Item number 8 on our calendar is House Bill 2261. Representative Jernigan, you have a motion and a second. You are recognized on House Bill 2261.
Thank you. Thank you, John Warren. Appreciate that. Madam Chair, this House Bill 2261 is brought to me by the Tennessee Hospitality Association and working with the ABC. It does some administrative changes. It does 5 changes. I'm gonna go through them real quick. One change is the Synchronizes business licenses. So if you have more than one business, then instead of renewing 2 or 3 throughout the year, you will synchronize and have one renewal date if you choose to do so. It also does electronic verification that in addition to paperwork you have, you can also be able to show that you're in compliance through electronic means such as through your phone. It also does for catering. The caterers can give a 2-day electronic notice and get a receipt from that, and also allow the wholesaler to deliver straight to a catering site instead of through the restaurant, then to a catering site. And last, it also does a notification for a violation of the owner. So during the renewal process, the owner will put their name and email address down, and the violation will go directly to them instead of a third party. So with that brief explanation, I'll be happy to answer any questions, Madam Chair.
Are there questions for the sponsor? Seeing none, we're voting on House Bill 2261. All in favor, please signify by saying aye. Aye. Any opposed? The ayes have it. House Bill 2261 goes on to calendar and rules. Next on our calendar is House Bill 1999 by Representative Jernigan. We have a motion. We have a motion and a second. Representative Jernigan, you are recognized.
Thank you, Madam Chair. This bill directs the Board of Pharmacy to promulgate rules that will ensure that an individual who is visually impaired will have appropriate access to prescription labels and related materials appropriate to their needs. And with that explanation, I'll be happy to go further. Thank you.
Questions? Question has been called without objection. We're voting on House Bill 1999. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1999 goes to calendar and rules. Thank you, Representative Jernigan.
Madam Chair, members, thank you.
Brings us to item number 10 on our calendar, House Bill 1201 by Chairman Whitson. We have a motion. We have a second. Chairman Whitson, you're recognized.
Thank you, Madam Chairman. I think we have an amendment, new amendment we want to put on that helps clarify this legislation. And I'll defer to Chairman Williams on that.
All right, we have a amendment, drafting code 017792. Is that the one you have, Chairman Williams?
Yes, Madam Chairman.
It is untimely filed. We do need a motion to consider.
Motion.
We have a motion, then second.
Second.
Without objection, we will be considering 017792. Chairman Williams, and now we have a motion on the amendment and a second. So Chairman Williams, please.
Thank you, Madam Chairman. Just to clarify the posture that we're in, the subcommittee made an amendment to this bill, and subcommittee, that amendment is still traveling with the bill, and this would be an amendment. The Speaker's office and Colonel Whitson have been working diligently with interested third parties regarding some of the concerns that they have, and so this bill or this amendment is an attempt to try to ease concerns and further clarify what the intent of the legislation is to do. I will say that the reason for this bill stems a lot as it relates to a Supreme Court case involving Citizens United that ruled that no one could restrict communications, nor could they force people to disclose who their contributors are. And so even the original bill, this bill, and the other bill does not, that it meets those requirements as it relates to those two results from that Supreme Court case. And so with that being said, in subsection B of the amendment, it clarifies that this does apply to only state candidates. I think previously there was some concern of whether or not these reporting mechanisms to further transparency would apply to local candidates. This clarifies that it does not. It also seeks to clarify 3 areas that are not deemed communication, and those 3 areas are if you have any oral, written, or electronic transmission of any documents to those people who are the members of your group. So if you wanted to send it to somebody that were members, you could do that. But if you wanted to send it to a group of people from a zip code or a voter file database, that would be different than who your members are. And this separates the difference between those two. It also seeks to clarify that any of the communication, these communication or this bill would not apply if we were in a special session that was within 60 days of an election, either a primary or special or whatever. So if we were in special session or in session, that it would not apply, allowing you to be able to those groups to be able to communicate about what's going on and the work that's going on here. And then third, it determines what the if you did a report prior to the 60-day period and that report was listed on your website, as long as it was something that you did in your regular business, then you could continue to do that of your entity. But if you went to direct people to that, or even if it was an older report, or spent $5,000 or more trying to distribute that information, then that also would not apply. So with that, Madam Chair Lady, I'm happy to answer any questions members might have.
All right. You've heard the explanation of the amendment. We are on the amendment. Are there any questions? Seeing none. Leader Camper, I'm sorry, I didn't see you.
I know you didn't say, thank you. Thank you, Mr. Sponsor of the amendment. I talked to you earlier about the portion on the pre-check. Could you explain that to us for the record?
Yes,
Chairman
ma'am.
Williams.
Yes, ma'am. Thank you, Chair Lady. The pre-check was discussed in the previous amendment. What happens sometimes is entities will send mail, solicitation mail to individual person's house, asking them to be a member of their group or a platinum member of their group or whatever, and they would go ahead and check the box that says that you accept being this member. And what had happened is we believe that the individuals have to check that box themselves without having it checked for them. That way it eliminates any fraud or miscommunication about what the actual person wanted to do. And so you cannot have pre-checked boxes anymore.
Thank you. So this would not apply to an ongoing monthly contribution I might want to make to someone that has asked for a donation, and this is, would you like to make it monthly? And then you hit next. Would that be a problem?
If it was
Chairman Williams.
thank you.
Yeah, electronically, yeah.
Yeah, if it was electronically, they couldn't be a pre-checked box. It would have to be an empty box of which
And then
you,
I would have to check it to say yes, and that's okay, right?
yes,
Chairman
ma'am.
Williams.
Okay, thank you.
Representative Miller.
Thank you, Madam Chair Lady. Reading the amendment, it states it requires each candidate for chancellor, circuit court judge, criminal court judge, or a judge of a state trial court of a record to submit a disclosure statement. Conflict of interest, is that accurate? Is that part of the amendment?
Chairman Williams.
Yes, it is still, it was a part of the previous amendment, but it still applies here. The rule of code of conduct for judges is different than it is for us, and currently it's not required, although some will fill out statements of interest. This would require them to fill out statements of interest.
Yeah, as we fill out this conflict of interest on an annual basis or whatever, how often would the category of judges have to fill out a a statement?
You just have to do it one time.
They have to do it one?
Yes, sir.
Every 8 years?
No, one time every year during that cycle. Just like we do.
Okay, thank you.
Chairman Whitson.
Yes, Representative Miller, what that was added, we found out that those judges were left off the disclosure requirement form, and the registry brought that to our attention. That's why we added them.
Additional questions? All right, we are voting on the amendment 017792. All those in favor, please signify by saying aye.
Aye.
Any opposed? The ayes have it. Amendment 17792 is hereby attached. We are now back on the bill as amended. Question has been called on the bill. Any objection to calling the question? Seeing none, we're voting on House Bill 1201. All in favor, please signify by saying aye. Any opposed? The ayes have it. House Bill 1201 moves on to calendar and rules. That completes this calendar for today, but we do have our constitutional amendment calendar that we will take up next, members. So you have that on your dashboard if you don't have a paper copy. Okay, we'll give everybody a minute to find the calendar and associated information. All right, members, we are now on the constitutional calendar, and item number 1 on that calendar is SJR 55 by Representative Reedy. We have a motion and a second. Representative Reedy, you're recognized.
Thank you, Madam Chair and members. This bill is a constitutional amendment cleanup. It proposes amendment to remove Article 9, Section 1 of the Constitution of Tennessee, which provides that no minister of the gospel or priest of any denomination whatsoever shall be eligible to a seat in either house of the legislature.
Heard the sponsor's
Taking it out.
explanation. I see no questions. We are voting on SJR 55, which I believe may happen shortly. Item number 2 on our calendar, I will turn this over to Chairman Hicks.
All right, members, item number 2 on our calendar is SJR 715 by Chair Lady Hazelwood. Chair Lady Hazelwood, you have a motion to second. You're recognized.
Thank you. This resolution just will amend Article 2, Section 31 of the Constitution to allow the investment of state funds in equities, that is stocks. Currently, the Constitution prohibits that, and it does inhibit our ability as a state to take advantage of some investment opportunities, and that in turn inhibits the state's ability to provide needed services to its citizens. So the proposed amendment language, if approved by the citizens, would provide that state funds can be invested in equities with the adoption of an investment policy. That policy would be developed by the governing body or state official charged with carrying out the purposes or objectives of the fund or trust administered by the state, and that policy would have to be approved by the state treasurer and the comptroller. And as you all know, the constitutional amendment process is a fairly lengthy one, and rightfully so. It's a big step to modify the Constitution. If the amendment is passed during this General Assembly, it would then have to be passed during the next General Assembly by a 2/3 vote to be placed on the ballot in 2026. With that, Mr. Chairman, I stand ready for questions.
All right, thank you, Chair Lady Hazelwood. Members, you've heard the description of SJR 715. Any discussion? Representative Miller.
Thank you, Mr. Chairman. Madam Chair Lady, in your explanation, you mentioned that the treasurer and the comptroller would be the deciding factor in any policy changes or any investments. Those two individuals would have the, I guess, ultimate authority of.
Just for clarity, let me read you the exact language or the statement. The proposed amendment language provides that state funds may be invested in equities with the adoption of an investment policy that would be developed by the governing body or state official charged with carrying out the purposes or objectives of the fund or trust administered by the state. That policy, whether developed by the governing body or the state official, would then have to be approved by the state treasurer and the comptroller.
Representative Miller.
So there's a governing body and or an official who will establish the policies and then present those policies to the comptroller and the treasurer. I just wanted some clarifications to see how.
And Chairman Hicks, we do have the treasurer with us just to, I'm sorry, the treasurer's representative with us. And just for clarity's sake, this is important. It is a constitutional amendment. If we want to go out of session and hear from him, then.
Okay, we can do that. Members, without objection, we're going to go out of session to hear from the Department of Treasury. So without objection, seeing none, we're now out of session. If our guests would please come up to the microphone, please identify yourself as we get started.
Thank you, Mr. Chairman. My name is Roy West, Chief of Staff for the Tennessee Department of Treasury. To clarify, the treasurer is actually walking down at this moment. He's probably just about to walk in, but I'll start. Roy West, Chief of Staff.
Yes, my name is Thomas Kim, Deputy Chief Investment Officer at TCRS.
All right, we're happy to answer any questions that you may have.
Representative Miller.
Thank you. Again, the question based on the language, who would have the authority to make the decision of let's say, what banks to purchase stocks in, or who would make that decision to purchase Amazon stock, et cetera, et cetera?
Yes, thank you, sir. The investment policy regulates the asset classes that the overall investment team can invest in. We have investment analysts who then determine what is best for the individuals or the beneficiaries in the plan to ensure that we get the best return. So those analysts research and then determine with a fiduciary interest that we make the right decision.
Thank you.
Representative Hall.
Thank you, Mr. Chairman. Mr. West and your team, you're doing a very good job. Thank you. Tell us again, this is not unprecedented. We're doing this now. The Treasurer's Office is doing this now with other funds. So if you could please tell us which fund we're talking about with this constitutional amendment and follow up with other funds that we are already making investments of this nature in. If you could, please, sir.
Thanks, sir. Currently, the Department of Treasury is able to invest in equities with the Tennessee Consolidated Retirement System, the Chairs of Excellence, and the Tennessee Promise Fund. This amendment would allow for other state funds that are deemed necessary to be invested in equities. So all state funds would be subject to this if there was a need and it was deemed appropriate by the comptroller and the treasurer, who is now here, and I'll allow him to take over.
Mr. Treasurer, thank you for being here. And if you would just, we all know who you are, but just to get you on the record, would you please just state your name?
David Lillard, Tennessee State Treasurer. It's my pleasure to be here.
Thank you, sir.
And Chairman Hicks, if I might, I
Chair
would
Lady
like
Hazelwood.
everyone to note that the treasurer has on his tie with numbers on it today.
That's right.
Some
If you're
people
in
might
House
be able to
Finance,
see
you get
it
over the
from here.
appropriate attire and numbers on your tie. Yep. So.
All right. All right, let's go to Representative Sexton.
Just reading the bill, I was interested in the part that says, and it may not be relevant, but I suppose that it is, invested by the Treasury that contains state funds in whole or in part to adopt and approve of the Treasurer and the Comptroller of the Treasurer, an investment policy to authorize all or part of such funds or trust to be invested such that the state would become the owner, and this is what I'm interested in, the owner in whole or in part of any bank or stockholder. What does that mean?
Mr. Treasurer.
Could we own a bank?
It means equity securities. That's using the original language from the 1870 Constitution. For some reason, they wrote in a very stilted way back then that the state would not be an owner of any bank, association, et cetera, et cetera. And that's really kind of odd language for today's world. It's really equity securities is what it means. And why they expressed it that way back then, I don't know. The Attorney General's office, when they drafted our amendment, wanted to use that same language again, I guess, because that's historically correct in regard to the Constitution's language. But that's what it means, is just stocks of any type.
Representative Sexton.
So it's not possible that the state could own a bank?
Oh, it is possible the state could own a bank. I mean, you can buy an index of bank stocks today, the MSCI Financial Index, and own stocks of many banks simultaneously. So it's quite possible you could do that. When you say own a bank, Chairman, it's not in the sense of us trying to obtain control of a bank or anything like that. It's just buying for the purposes of return, to generate a return, So we might own a small amount of stock, in a particular financial institution or any other type of entity. It's in any other business.
Representative Sexton.
So you wouldn't in any way think that the state could own and operate a bank on its own?
No, that doesn't authorize us to do that. No,
Okay.
It does not.
All right, thank you. Further discussion for our guests? Chairman Williams.
Thank you. Mr. West, I just had a quick question for you. Could you tell us again what your title is?
Thank you, Mr. Representative. Roy West, Chief of Staff, Tennessee Department of Treasury.
Okay, I think you also had a title previous to that. I think you earned as an intern in a very good office, one of the members here in this body. But could you share with the body what your title was as my intern?
Thank you, Chairman. The official title was Ambassador West.
Yes. Like the body to recognize Ambassador West and his great achievements in the Treasurer's Office. Thank you.
Thank
All
you,
right.
Chairman. I learned a lot under you.
All right, members, further discussion? Seeing none, thank you all very much for being here. Without objection, we're going to go back into session. Without objection, we're back in session. We're back on the resolution. All right, question has been called. Objection called on the question. Hearing none, seeing none, we're now voting on HJR 715, moving on to calendar and rules. All those in favor say aye. All those opposed, no. The ayes have it. HJR 715 moves to calendar and rules. Chair Lady Hazelwood.
Thank you, Mr. Chairman. That does complete both our calendars for today. But I believe Chairman Zachary has an announcement.
Thank you, Madam Chair. Members, calendar and rules will meet at 3:30. So if you've had a bill, we have some moving parts with calendar and rules. So if you had a bill that has come through or was on our regular calendar, was printed yesterday, you need to be on standby to present your bill. Thank you, Madam Chair.
Thank you. Without further business, we are adjourned.